Greetings, everyone. Dwayne Daters, your local friendly public defender here to talk a little bit about the implementation of the Safety Act. In this video, I'm going to try to give you a little information so you can feel like you know what to expect in about 2 weeks. I'm not going to go into depth because to do so would result in a video that is 1 and possibly 2 hours long. So let's get started. Obviously, our conversation starts with the police encountering a suspect. If the person provides proper identification and the crime is not a felony or Class A misdemeanor, in most circumstances the police are to issue a citation and schedule a court date. Now, if the police believe that the person is a threat, or the criminal activity can persist, or the person has a mental or medical issue that poses a threat to the person's own safety, then law enforcement can arrest the person. There is discretion here allowed for the police officer. Now, if the suspected crime is a Class A misdemeanor or a felony, it does not necessarily mean that the person will be arrested and taken to jail. Again, there is some discretion. So assuming the person has been arrested, brought to jail, one of the first rights they have, which is not new by the way, is to make 3 phone calls within 3 hours to an attorney of their choice or a family member. Law enforcement must keep track of these calls. Is the offense for which one where pretrial release may be denied? If that answer is yes, then the person must be brought before a judge within 48 hours. There is a question among stakeholders involved as to when that 48-hour period starts. Because let's face it, some counties are small enough where they're not able to staff daily court. So some jurisdictions are interpreting this requirement in conjunction with other statutes to say that weekends and court holidays do not apply. They will have what is called a Gersten hearing, meaning a judge will review a police report, determine if there is probable cause that an offense has been committed. So we assume that happens. Now, initial appearance before a judge is to be held. What happens at that hearing? Well, prior to that appearance and with sufficient time for an attorney-client meeting, the court shall appoint counsel to represent the person for the purposes of that hearing. That is, unless a private attorney has already been employed. The defense attorney must be given an adequate opportunity to confer with his new client prior to the first appearance hearing. The attorney is entitled to all documents relied upon by the state to detain or in setting conditions. If the state files a verified petition to detain, a detention hearing will be scheduled within 48 hours if a felony or 24 hours if a misdemeanor. Alleged victims have a right to notice of this hearing. Evidence can be presented by the state or defense by a proffer, which is an attorney relaying to the court evidence that they would expect to present, or by calling live witnesses. If no petition is filed, the person is to be released with whatever release conditions have been deemed appropriate on a individualized basis. The court shall take into account nature and circumstances of the offense alleged, the weight of the evidence, the history and characteristics of the person charged, including the defendant's character, physical or mental condition, family ties, employment, financial resources, length of residence in the community, community ties, his or her past relating to drug or alcohol abuse, conduct, or history, criminal history, and a record concerning appearance at court proceedings, and whether at the time of the current offense or arrest the defendant was on probation, parole, or on other release pending trial, sentencing, appeal, or completion of sentence for an offense under federal law or any other state law. The nature and seriousness of the offense and the specific and real present threat to any person that would be posed by the person's release, the nature and seriousness of the risk of obstructing or attempting to obstruct the criminal justice process will also be considered. It is important to note that these conditions shall not mandate rehabilitative services unless directly tied to the risk of pretrial misconduct. The court shall not include punitive measures such as community service work or restitution, and they must be in accordance with national best practices as detailed in the pretrial supervision standards of the Supreme Court. Electronic monitoring, GPS monitoring, or home confinement can only be imposed if no less restrictive conditions would reasonably ensure appearance or protect identifiable person or persons from imminent threat of serious physical harm. The basis for these conditions must be set forth in the record. In domestic violence, violation of order protection, kidnapping, and harassment type cases, the court may consider additional factors such as the defendant's propensity or reputation for violent behavior or lack thereof, psychological, psychiatric, or other social history tending to indicate a violent or assaultive nature or lack of any such history. In setting release conditions, the court normal or standard release conditions are to appear in court on a certain date as ordered by the court, submit to orders and processes of court, not to violate any criminal statute of any jurisdiction. The conditions, in addition to that they can set, are only when determined necessary to ensure the defendant's appearance in court, to ensure they do not commit any criminal offense, ensure compliance with the conditions of pretrial release, prevent unlawful interference with orderly administration of justice, ensure compliance with problem-solving courts. However, these must be the least restrictive means and individualized. Conditions cannot mandate rehabilitative services unless tied directly to the risk of pretrial misconduct. These can include not to leave the state, to report or appear in person before a person or agency as court directs, not to possess a dangerous weapon, no contact with certain people or to go to certain places, to be placed under the supervision of a pretrial agency, to have an ignition interlock installed on their car, to comply with a protective order, sign a written admonishment to keep their address current with the circuit clerk, and such other reasonable conditions as the court may impose, so long as these restrictive means, again, are individualized and in accordance with national best practice. I would note there is no clear association between drug testing and improving either public safety or rates of appearance, and there is no clear association between electronic monitoring and improving public safety or rates of appearance. If the person is placed on electronic monitoring, GPS monitoring, or home confinement, the court shall determine every 60 days if no less restrictive condition of release or combination of less restrictive conditions would ensure the appearance of the defendant for later hearings or protect an identifiable person from imminent threat of serious physical harm. If the defendant is still in custody after 48 hours when ordered released with conditions, the court must review why they are not released. Now, after the conditions hearing, at every subsequent hearing, the judge must find that the current conditions imposed are necessary to reasonably assure the appearance of the defendant as required and the safety of any other person and the compliance of the defendant with conditions of the release. The court is not required to be presented with new information or a change in circumstances to remove pretrial conditions. So moving on to the detention hearing. Prior to this occurring, the state must tender to the defense copies of the defendant's criminal history, any written or recorded statements, and the substance of any oral statements made by any person, including the defendant, if relied upon by the state in its petition, meaning the defendant is entitled to some limited discovery. Again, evidence can be presented in the same fashion as at the conditions of release hearing. The defendant can even testify, but for various reasons, this may not be in his or her best interest. While the defendant can request that the complaining witness appear, my personal belief is that it will be rare that the court grants that request. If detention is ordered, a trial must occur within 90 days unless delay is occasioned by the defendant. Currently, the speedy trial demand is 120 days if you're in custody or 160 days if not. At each and every subsequent hearing, meaning every time the defendant comes back to court, the judge must find that needed detention is necessary to avoid a real and present threat to the safety of any person or persons or the community based on specific articulable facts of the case, or to prevent willful flight from prosecution. It is important to note that in any hearing where release is denied, it can be immediately appealed. Now, moving on to those offenses where the state can file a petition to detain, it includes any non-probationable offense, and it is alleged that the person poses a real and present threat to any person in the community based on specific articulable facts of the case, or willful flight. Willful flight means intentional conduct with a purpose to thwart the judicial process to avoid prosecution. It is important to note that a history of failing to appear in other cases in the defendant's life is not allowed to be counted as willful flight. So the part that most of you probably are waiting for, the list of offenses where a person can be detained by name, include treason, first-degree murder, second-degree murder, armed robbery, aggravated robbery, robbery, burglary where there is use of force against another person, residential burglary, home invasion, vehicular invasion, aggravated arson, aggravated kidnapping, aggravated battery resulting in great bodily harm or permanent disfigurement, or any other felony that involves the threat of or infliction of great bodily harm, permanent disability, or disfigurement, and basically any sex offense. People can also be detained when the charge is stalking or aggravated stalking and there is a real and present threat, and denial of release is necessary to prevent completion of the threat. People can also be detained for violations of orders of protection or domestic battery when there is a real and present threat. For the most part, what this means is that any offense involving violence or threat of violence against a real and specific person or a member of the community, that person can be detained. So the point I would add that offenses that you did not hear me name, such as retail theft or Class 3 and Class 4 possessions of illegal drugs, they're not included. And I'll repeat an earlier comment that I made, that the court in setting release conditions cannot order punitive measures such as community service or payment of restitution, nor can it order that that person enter into any type of rehabilitative treatment in order to be released. So, in a nutshell, this is what is coming your way in about 2 weeks. For a more thorough and detailed explanation, check out the flowcharts and videos put out by the Supreme Court of Illinois Pretrial Implementation Task Force. You can easily find that with a Google search. There's several videos out there, and you can spend hours combing through it. I do hope that you have found this video informative and that you feel like you know a little bit more today than what you did yesterday on this topic. Thank you, and have a great day.